James says it appears to be the Adobe Flash.
Yeah,
And
yeah.
I couldn't hear you at all on the show. So I rebooted my machine and it wanted me to install my Adobe Flash. And I did that. So, but that wouldn't hurt the live stream because I didn't have it open. So.
Okay. I've got some kind of nasty Adobe Flash crash problem on my computer. And I apologize. I've got the internet fixed, so now I've got to fix Adobe Flash. And I deinstalled and reinstalled that yesterday, so I don't know what's going on. And I think, can you guys hear me? Give me feedback. Can you hear me? Hopefully you can hear me. If not, I'm going to stop this and start over.
CJ, you're up. You're live.
Am I live? Can you hear me?
Renee just called and said, my speakers aren't working. I can't tell.
Okay. Oh, God. Okay, we're going to try to get this. Okay, Randy says yes, he can hear me. Thank you, Randy. All right. I'm going to start over with the I don't know where it crashed. I apologize. I will do everything this, and so that's going to take my whole afternoon is to figure out what is going on with Adobe Flash. So I don't know. Anyway, go to my website, hofj.org. I want to talk about the draft statement of suspicious documents, and I sort of reorganized my website into some big categories with subcategories. So under foreclosure defense, and right now I just linked these documents and some samples on the notary page. So I went to go to foreclosure defense, go down to the notary complaints page. When that loads, you're going to see here, I just, in big orange letters, draft statement of suspicious documents. I just PDF'd it. I want to review that with you. I have sample docs, and I want to show you the thought process. And I'm going to run through this quickly because I'm thinking that most people watching are experienced and understand what I'm talking about. I will do a slower step-by-step explanation of what these documents are: assignments, trustee substitutions, notice of default, and that kind of stuff for novices and for owners. So on the statement of suspicious documents, if you can bring it up on your screen so that you can follow along, because I'm going to whip through this, and then I'm going to bring one up that I've been filling out on those on the document, sample documents. So the idea is, what we want is something fast, something people can do quickly, and that they are comfortable making zillions of copies about. So let's think about this. The plan is to plaster the planet, to make 15 copies and pass them out not only to the local officials or mail them to recorder, DA, sheriff, the supervisors, attorney general at the state, but media. We're talking about sending them to the mainstream media. So here's part of the issues that we may want to consider, and that is we have two sets of these statements. One with the person's name, signature, and their name and property address and everything on the documents for local officials, for the ones I just named. But for media, we may prefer, just give me your feedback, may prefer to take this same document and the work that's been done, but white out the person's name and address. Because the mainstream media is not necessarily going to, maybe, I don't know. Tell me what you think. I'm just thinking this out loud. So nevertheless, the idea is you have a summary of the name, the address, the date of the deed of trust or mortgage, because that is the date that will be used for the cutoff date. 90 days after the date of the loan is the cutoff date of the securitization trust. So then there will be the document list with exhibits, and those will be appropriately edited. I'll show you what I've done so far on that sample. And then these are the suspicious items: the false notarization, false signatures, as much proof as a person can get. Any assignments that are recorded after the notice of default in California, the law reads, and I think probably in most states, but I don't know that for sure. I haven't checked every state. But the notice of default, if recorded prior to the shift of whoever did that recordation, prior to the assignment, it's illegal, it's void. It doesn't work, has no effect. And that's why just the order of when the documents are recorded can make such a huge difference. People don't know this, and judges are just throwing that stuff out, saying even in court that it doesn't matter as long as it's filed, but actually it does matter. And we're not in court. We are taking this to the public and to the Attorney General for statewide grand jury and to our district attorneys in the county level to show them proof of illegality, the suspiciousness of these documents. Impossible beneficiary, we're going to talk about that. For example, if a bank has assigned the beneficial interest into the trustee of the mortgage-backed securities, that's an impossibility. And I'm telling you, the attorneys do not understand this. So we're trying to make that simple. A fake title, like an attorney-in-fact designation. And I believe, I've been assured that what I've said before is true, without a power of attorney either included with a document or recorded in that county for that signer having the power of attorney for that entity, it's fake. Here's the violation of the MBS trust cutoff date. So any securitized loan assignment after the trust cutoff date is illegal. It's not allowed by the PSA. And I'm trying to get the quote out of standard quotes out of a pooling and servicing agreement to include. I don't have that yet. Conveyance from a defunct lender. That doesn't happen very often, but it could. They're conveying from some entity. This is how some lawsuits have been actually won, because they proved that the lender that theoretically was doing all this stuff had already been closed down. So that it could affect particularly people that have already lost their homes to foreclosure. So it's very important that everybody, whether you're fighting it, haven't even gotten a notice of default, there's some things you can do and should start doing right now to push that off, but also those that have lost their homes to foreclosure. Here's MERS receiving value or assigning the notes without the authority to do so. Many courts have said, particularly in bankruptcy, that MERS may have authority to do something with the deed of trust, but has no authority to manipulate the loan, to assign that loan, the note. However, there may be, has been pointed out to me, one of the ways the banks are fighting back against that is, I have a corporate resolution and MERS can do that for me in my notes. So there may be corporate resolutions that could sidestep this illegality, but I think we should point it out anyway. And then a contempt of court, because I've included the exhibit A, item 1, which specifically talks about what the banks have to do, and they agreed to do as of April 4, 2012. So any document that's been recorded after April 4, 2012 that violates this consent judgment by robo-signing, forging, other deceptive tactics. So any one of these up here in this area, if they are recorded after April 4, 2012, you'd put that document number down here too. And there may be other items. If you can think of anything, please let me know. Tell me what you can come up with. And then I would want the law quoted. Here's the law. I want to go through this quickly because, of course, the 115 and 115.5 penal code, every state has penal code like this. And so this, California is a guide to what you can find out for your state if you're not in California. But obviously, any person who offers knowingly false or forged instruments, and I swear that as we swamp our DAs and our attorney generals with these proofs of suspicious documents and these forged signatures, because we're going to get proof that these signatures were forged, proof that would hold up in court, and that then what I've asked for is an injunction. I want these foreclosure mills stopped They can't file. They can't send any more documents. That's number one. That's what we should work for, number one. Then we go after, 3 hots and a cot, put them in prison. So in California, foreclosure code, and we're a deed of trust, a non-judicial state. So if you're a non-judicial state, your codes are probably very similar to these, and you can research your statutes and then be able to quote the ones for your state. As we have more help, we'll try to do that for state after state after state. So owners in other states can just take a statement of suspicious documents like this already pre-prepared for them. Here is the 2924.17A, and this is part of the SB 900 Homeowner Bill of Rights. They changed that code to say that anybody that's going to file any of these, notice of default, sale, assignment or substitution of trustee, all of that has to be based on accurate and complete documentation and supported by competent and reliable evidence. That's the loophole. That's the standing loophole, if you will. That's how people are going to be able to fight back in court. The 2924.19 talks about how any violation up here in this one has violated that entity's licensing law. So this is how we're hoping to get the Recon Trust, the Cal Reconveyance Index. Index West is not California, so we're not going to be able to get anybody in California to stop Index West from filing documents in this state. Not with a grand jury. They can only look for foreclosure trustee mills that are positioned in this state. They have an office in this state. So that's another issue that we need to get the rest of the country to understand, and then their states have to step up for these other foreclosure trustee mills. Third-party encumbrancer, that would be like I believe, correct me if I'm wrong, please, I believe that's like Recon Trust, Cal Reconveyance. They are third-party encumbrances. They are subcontractors from servicers, and therefore, and I used to think it was the master servicer, but the master servicers have actually sold off servicing to their offshore dragons. So B of A has sold it off to NationStar, Ocwen, Chase Wells. They've all sold that servicing. And I believe that they're trying to wiggle out of any oversight. Oh, well, these aren't they're even though they're wholly owned subsidiaries, they're trying to claim that Ocwen's a wholly owned subsidiary, but, I don't have anything to do with it because I just sold them the servicing. So you have to go after them separately. And it may be that we do so. And Renee sent to me just this morning the servicer consent orders, I believe. So I haven't even looked at them. I apologize, but I'm going to upload them, and we'll maybe she can talk to us about them. Then I want to show you the 2934A1. That's the code that discusses trustee substitution, and it has to be done. The substitution has to be executed and acknowledged by all of the beneficiaries under the trust deed and their successors in interest. And the code goes on with other stuff if there's multiple beneficiaries and how that has to be done. Then I've quoted four rulings coming out of lawsuits: Bank of America versus La Jolla Group, Dimrock versus Emerald Properties, Trout v. Trout, Wutzke v. Bill Reed Painting Service, and each one of these talks about basically if any of these assignments or trustee substitutions are void, the foreclosure is void. So this is very important. I want to remind everybody that's looking at this, and that would be the prosecutors, that these are the laws, and when these documents are void, then the foreclosure is void, because that's what 4 million people want to know. They took my house illegally. Can that be, reversed? I wanted to really point this one out. This is really huge. Most of us don't know this. It's U.S. Code 1641F1. A servicer of a consumer obligation arising from a consumer credit transaction shall not be treated as an assignee of any such obligation for purposes of this section unless that servicer is or was the owner of the obligation. And you and I all know that the servicers were never the owners of the obligation. They never were, and they never are right now. So on one of my samples, you're going to see how MERS assigned this to the servicer, and that's illegal. That's a violation. That is on the face of the document wrong. It's void. It has no effect. It's not allowed by law. And then in that same USC 1641 G1, I've included more quote of the law about how the creditor that is a new owner or assignee shall notify the borrower. So the fact of the matter is, even if any of these assignments and trustee substitutions are legal, if they are or were, then the person should have been notified 30 days. So if they didn't do that, then they violated that. This 18 USC 1341 is just mail fraud. This is if you deliver it in the mail and it's known to be fraudulent. Here's the code. I just quoted it. Here's the contempt of court for the consent judgment. And all of the exhibits for all of the mega banks are the same. And this is, and I've named them, GMAC, B of A, Chase, Citicorp, and Wells, and their third-party providers continue to robo-sign, forge, and use deceptive tactics in violation of the consent order. And so this is the quote. You can read the quote. Now, when you pull up this document on the website, I've quoted this. Now, down at the end of this, I've got IRS 860, because that has to do with the cutoff dates and assigning the notes, and the standard statement from the PSA. I don't have that yet. I want to include that. This is a draft. That's why I've called it a draft, and I want to show you how it looks when you fill out one based on the documents. So here is the sample, and it's based on the documents from this website right here, the sample docs. So the sample documents, I've whited out the property address and the person, but this is a real life example, and this is what owners could actually use the statement of suspicious documents as a checklist. They can put this together themselves and then say, oh, I need to do this, I need to do that. So on the suspicious documents, in this particular case, the deed of trust was 4/17/2006. So we know automatically that any assignments that were done after that, violated that rule, that they can't be legal assignments. Now, in this case, what I've done is I've highlighted who wants this recorded, request recording for information, the number, this is the document number, the date, I highlight whichever county, because when I'm collecting them from all over the nation, then at least we can see which county and state these documents have been recorded in. As we, for example, in this one, it's Jane Martorana. So as we get more and more documents of Jane's, they could be from anywhere, and we can compare those signatures. This is an assignment of deed of trust, and here MERS is assigning to, and this is what I just referred to, Bank of America, N.A., the bank, successor by merger to BAC Home Loan Servicing, LP. This is a servicer, and this is a violation. This is a direct violation of that code we just talked about. And then you see when this was dated. This is why I've highlighted it. April 27. Is that after April 4? Yes. Violates the consent judgment. Then as we go down into the second page, this is the notary, and we're recommending everybody get the oath, get the original notary signature from the oath if possible. Secretary of State, you can get it by email. Here in California, in Texas, in California, you have to send in $6 to the Secretary of State. They'll send you back a certified copy, and I do recommend that you get the certified copy of that signature. Send the certifications on the back, so you can still just make copies of it. Send me that signature for each of these notaries so that we can start uploading on suspicious documents and everybody can use them, because then we'll discover, does that signature really look like this guy Emmanuel Adatula? And I don't know if I have not received his official signature. I wanted to point out to everybody and help me understand this. Is this legal or not? I think this is a problem. I've identified here that this line right here is blank. So on this assignment, this has got to be blank. And maybe I should add that if anything is notarized in blank, it's illegal. So, Rob, tell me, is that illegal? I haven't even had a chance to ask him. I just noticed that this morning when I was putting this together. So share with me any other ideas you have that we can put on this statement of suspicious documents. So this is the first assignment. So what we did here was we put the assignment, the number, what date it was recorded, and then a notary complaint filed. Now, if the person whose property this is has or has not filed, they should. They need to get the oath. They need to get the original signature. They need to file a complaint with the Secretary of State, and then copy that information into, as an exhibit for item 1. They also should go to the that notary, Emmanuel Adatula, and ask for the journal entry of that signature, and then collect any other signature samples we have online and make that all as an Exhibit 1 package. The next thing that was filed on this property is a corporation assignment of deed of trust and mortgage. And again, now this was asked for by Recon Trust. You'll note that it was filed 7/10. In fact, all 3 of these were filed. The next 3 were filed just boom, boom, boom. And you'll see by their numbers. So here's the corporate assignment 01. Here's a trustee substitution 02. And here's a notice of default 03. And so this is why owners need to understand you're not going to get typically the assignments, substitutions, until you get the notice of default, and it's filed just boom, 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 virtually all at the same time. It hits the recorder's office, stamp, 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 right in that order. And so on this corporation assignment, here you've got the B of A. See, we saw the B of A as successor by merger to back home loan, so we know that assignment is illegal. So this assignment has to be illegal because it's based on the first one that's faulty. But nevertheless, it's faulty on whoever's issuing it. Shouldn't even have the authority to do that because they're never the assignee of the servicer. They're servicers, not assignees. They're now assigning to U.S. Bank National Association as trustee for this mortgage-backed security. And that is illegal, and that's the banks cannot do that. That's illegal on its face. It's a fake document. It is meaningless, and yet the house is being foreclosed on it, based on it. So we need to get this information out to our prosecutors. And again, now here's Ramon Olivas, and this is our Lauren Stone signature. Again, July 6, 2012, so it's after the April 4, 2012 consent judgment, so it violates the consent judgment. So this is what I've written. So the corporate assignment, notary complaint filed on Ramon Olivas. And as owners do this and they file these complaints, they're not going to get a response to that complaint necessarily fast at all. It may take a year and a half. So they can at least include the complaint in their exhibits. And of course, the journal entry and signature samples of Lauren Stone. And if they've asked for that and not gotten anything back, and I have in the notary complaint, when you ask for a journal entry, I think they have 15 business days to respond. So what if they never get a response? What if it's a black hole time? Well, then that should be a statement here also, somehow. We need to put that in there. So the next thing that was filed on this property is a trustee substitution. So now, again, you've got B of A, successor by merger to the home loan servicing. So the substitution is illegal because it's based on that first assignment, which is violation of law. And again, you've got Recon Trust asking for this. And the undersigned is present beneficiary, so it states again that this is the beneficiary, which is illegal. Notice it's the same Lauren Stone, the same notary Ramon Olivas, same date. So again, it violates all of those items, which we'll look at in a minute. Then they have a notice of default, again required by or asked for by Recon Trust. And again, here's the date and number. And then you'll note that if you have any questions about it, contact U.S. Bank National Association as trustee, care of Bank of America. Now, I don't think that this owner has contacted U.S. Bank National Association as trustee to ask them about that assignment. That would be the next step. Call up U.S. Bank and say, hey, you have the assignment, and see what they say, because others have told me that when they do that, these trustees for the mortgage-backed securities, they just go, whoa, I can't do that. What? Not me. And so you've got this is just a continuation of the fake fraud structures of foreclosure documents. And then on this one, now again, you've got now Lauren Stone. So even on this one same property, they've got two completely different signatures of Lauren Stone, again on the same day, July 6th. So I would bring that up. And then the notice of sale, California Declaration. If you look on my website, if you go down here on foreclosure defense, I have California Declaration. Loans that were deeds of trust loans that were created between 2003 and 2007, those years, are required, any foreclosure documents are required to have the California, where is it here? The declaration that they tried to get in touch with you and stuff. And a lot of times these documents are false and fake. If they're missing, owners can get some recourse and get an injunction. But most of the time, these servicers are now just slapping it on every loan. They don't even care. It's just an automatic thing that they do. But it can't hurt to check it out for yourself as an owner. And then the notice of trustee sale, again by Recon Trust, the document number, the date, and you'll note here that is a different signature on October 12th. So on the statement of suspicious documents, since neither the notice of default nor the notice of sale are notarized, you can't go after any notaries or request that or get journal entries for any of these people. So the only thing that this owner can include on those documents would be signature samples. And as owners have sent me in lots and lots of documents, and I do not have them scanned and uploaded yet, but I will make that a next priority. Once we get this set, so give me the feedback, guys. Help me out with anything else I should add, any other different format you're thinking of. I'm already, as I speak through this, thinking of, in blank, if it's notarized in blank, maybe we should add that to one of these suspicious issues. And so basically this package would have this document, the pages of these suspicious, the information and suspicious issues, plus the code, and then behind that, the packets of information for document exhibit item 1, 2, 3, 4, 5. And I would say probably only the original signature samples, since they've got Lauren Stone on 3 of these documents, they don't need to duplicate that. So then on the suspicious issues, because there's there's a notary, and these 2 notaries are the same, there's 2 false notarization claims. And so I don't know if this person has actually gotten signatures, if they've actually filed complaints, but that's the idea. That's what they should be doing. And then here's the false signatures. And so you'd want to complain about, direct attention to the signature samples, if you can find them, of different signature samples for Jane and then of course Lauren. If you have a journal entry for either one of these. Oh, and also Sunita, because Sunita signed the notice of sale. So this is why I'm saying it's an owner checklist. They can go, oh, this is what I need to do. I'll go do the notarizations over here, and I'll go do the signatures over there, and I can use this as a checklist. And then, of course, servicer as illegal assignee. So anything that uses the Bank of America as a successor by merger to back home loan servicing, it's illegal. And so that would have been the first assignment, which got that beneficial interest, and then every time it was used again. So it was used here, and actually it was used in the notice of default, but only as a reference. Actually, that was Recon Trust, I believe. So 1, 2, 3, the fake title, there was no attorney, in fact, on any of these documents, so that's an NA. And I'm recommending that owners just don't edit the list of suspicious issues, just keep the list the same, and then just say that one doesn't apply, this one doesn't apply. Impossible beneficiary designation, number 2. It's impossible for the servicer to give interest to the trustee or the mortgage-backed securities. It just doesn't work that way. Violation of the trust cutoff date. Well, obviously, loan assignments that are recorded after the MBS trust cutoff date, they're illegal. They violated the pooling and servicing agreement, and so we need to have that quoted down there in our statements, so that literally any attorney, any prosecutor, any owner, any activist, and any media person can read the law. Let's get the law out there in an understandable manner so that they can go, wow, yes, and maybe what I should do, tell me your feedback, connect those laws with those items. Maybe, because nope, I haven't itemized them on this. Maybe I should say, okay, this is suspicious issue A, and then we have all of those, and B, C, D, E, and then we can go into the law and say this law applies to suspicious issue, to the best of our understanding, A, C, D, E, and that would connect. I'll do that. That's why this is a draft, and that's why I'm going through it, because then I can hear me think it out loud. You can hear me. You can give me your ideas. We can work this together, and we can get something that's really, really powerful, simple, straightforward, easy to do, easy to understand, and easy to plaster the planet, because that's the name of the game. We need to do it now, because the sooner we do it, the sooner we can get injunctions against these foreclosure trust mills. MERS conveyance from a defunct lender didn't apply on this. Oh, and by the way, I think I said in a live stream a while back that Countrywide Home Loans was defunct. No, it's Countrywide Finance or something that's defunct, not home loans. So it turns out there's just all these corporations running around, and the fact is the banks have become masters at the corporate shell game. They have nested corporations. So I've got, Randy sent me the link to finding the corporations on the Secretary of State website. I'll have that linked. I've gotten that from somebody else on a Facebook page from Utah. So as we grow and expand, we're going to collect these places where anybody can go and look up to see, is that corporation in existence or not, and check it against the loan documents they're using. MERS receiving value and assigning notes without the authority to do so. Okay, corporate resolutions might support the MERS authority. That's one of their workarounds. They create fake and fraudulent document anywhere and everywhere to try to circumvent some of these issues. So it may be that that isn't necessarily going to hold up. I think it is our duty to bring it to people's attention that various court rulings have said that is illegal, that MERS does not have the authority to transfer the beneficial interest in the note, only the deed of trust. So what good is that? And so let's point that out, and I'll probably reword that a little better. That it is illegal, but MERS might have some corporate resolutions or something. And then, of course, here's the contempt of court. And every document recorded after April 4, 2012 that directly violates the consent judgment by the robo-signatures, forging, fake notarizations, any of these other deceptive tactics like servicer as illegal assignee, a fake title, an impossible beneficiary designation. Any document that did that specifically after April 4 should be listed here. And in this case, all of his documents were after April 4, 2012. So every last one that's included on this list, and they're all based on this fraudulent forged assignment in the first place, then this is the point. This is on a servicer as an illegal assignee. Therefore, everything else just collapses. So that is that's what I've got to date, and these are the sample documents. So this is, I'm gonna get feedback, edit this, make it connect the laws to the suspicious issues as best I can, make a statement that we've done the best we can, and it may or may not apply, because of course, even if we're attorneys, things can be argued separately and differently and all that good stuff. We're just trying to educate and get a movement started. I'm telling you, it's really exciting when people stumble or hear about our efforts and our issues, and they say, oh, I look at the website and I actually feel like maybe it's worth fighting for. I got that from Pennsylvania. We got that this morning from Louisiana. Come on, guys. We are giving hope to the world. So help me out with this. Take a look at the suspicious documents. I've stuck it under foreclosure defense. I just put it on the notary complaint page. I have not set up yet a separate page for suspicious documents. I haven't had time. I will do that. And together, our minds together, we can do this. We can make a change. Thanks so much for listening and following along. I am thanking you right now in advance for any idea, effort, and help that you can give. And as soon as I can get this done, I will upload the Word document so that it will be editable. People can take it. They can get their documents. I promise as soon as I can, and we're ready to do so, I'll do a live stream on foreclosure defense, specifically on this. I'm going to have several ones. I think of all these people and all the questions that we get and what is needed. I'll find time to fit it in so that we can actually fight back and get this movement really off its feet. I want 1 million of these. 100 would be fabulous. 100,000 would be a movement. 1 million, we would change our laws and we would save our country. Thanks so much for sticking with us and watching live stream, and I will fix Flash Crash. If you have any ideas why my computer crashes with this, I would really appreciate the help. So we'll talk to you tomorrow. Thanks, guys. Live stream, weekdays live tomorrow. See you soon.